There's no shame of these justices saying, we can do this better than experts. We can do this better than scholars. We can do this better than scientists.
I wonder if that is room for evolution for her, if there's a little bit of cognitive dissonance she's perhaps experiencing when the rubber hits the road and the court actually has to decide these issues and does so poorly.
John Roberts is done trying to be an institutionalist.
Hi, and welcome back to Amicus. This is Slate's podcast about the courts, the law, the Supreme Court, and something we used to call the rule of law. I'm Dahlia Lithwick, and that's my beat. After Monday morning's release of the opinion in Trump v. United States, the work for us all now truly lies in understanding what the Supreme Court and the rule of law even mean for democracy itself, for all of us in its wake. This term was like none I have ever witnessed in 25 years as a journalist, and the ripple effects will be felt for many years to come. This is our annual breakfast table show where we sit with some of our favorite court watchers and try to piece it all back together. Joining me to talk through this past week, this past month, this past year are, of course, Slate's wonderful Mark Joseph Stern, the other half of my brain. Hi, Mark.
Hi, Dahlia.
And Dr. Mary Ann Franks, who is the Eugene L. and Barbara A. Bernard Professor in Intellectual Property, Technology, and Civil Rights Law at the George Washington University Law School. She's an internationally recognized expert on the intersection of civil rights, free speech, and tech. And her other areas of expertise include family law, criminal law, First Amendment law, and Second Amendment law. And her book, Fearless Speech, comes out this October. Please pre-order. Welcome back, Mary Ann.
Thank you so much for having me.
And of course, we have Steve Vladeck. His book, The Shadow Docket, is already on your bookshelves. It is on mine. Please order if you haven't. And his Substack has been my sanity the last few weeks. Steve is a professor of law at Georgetown University Law Center, newly installed. He's a nationally recognized expert on federal courts, constitutional law, national security law, and military justice. Welcome back, Steve.
Thanks, Dahlia. The military justice is going to serve me well when we all get shipped to Guantanamo in a couple of years.
Wow. We're going to start there? Okay. We're starting at rock bottom and working our way down. So listen, I want to gauge where everyone's head is at. We are taping this show on July 2nd, just about 24 hours after Trump immunity comes down. Most of us have probably read it through carefully at this point once or twice, and I'm experiencing it as seismic, no more and no less, for many reasons, not least of which is that the president, I guess, can now kill people if it's an official act, but also not just because of what it allows a future President Trump to do to democracy itself, but I'm just sitting with what this decision signals about how 6 members of this Supreme Court look at the Trump presidency, the events of January 6th, the threats that Trump speaks every single day, Project 2025, separation of powers. I mean, we got hyper-focused, I think, in this media cycle on Donald Trump himself, but I would really like to talk about what this says about the court. Steve, do you want to start?
Sure. I think when we did this last year, we talked about how the word of the term was arrogance. I think we've gone from arrogance to DGAF. Is my term for the October 23 term, not just because of the Trump case, Dahlia, but just the sort of, I'm struck by the message that the court has sent over and over again in almost all of its major rulings, that it just doesn't care about how half the country perceives it, that it just doesn't care. In the Fisher case, for example, that its decision is going to be held out as some kind of massive, victory and exoneration of the January 6th defendants. And it just doesn't care in the administrative law cases that it's going back on things it has taken for granted for 30, 40, 50 years. And it doesn't care because Dahlia just doesn't fear any retribution. It doesn't fear any consequences. Joe Biden's not running against the court in the election. He's running against Trump. And so the court is just, I think, doing what it wants when it wants. And what's remarkable to me is sometimes the other 5 conservatives are going so far that it's too far even for Justice Barrett. When Justice Barrett is the one saying, why are we doing this? I think that is quite a revealing and alarming signal.
Marianne, do you have a gloss on the DGAF court of 2023 term?
I think that that's largely right, but I think my takeaway mostly was when you look at cases like Rahimi and you look at cases like the FDA case about mifepristone, you also see the court avoiding its own messes, right? So it's a version of this, right? But it's saying we've basically created through Bruin and through Dobbs, we've created all of this havoc. And then when the natural and entirely predictable consequences of that havoc start to appear, the court then says, well, that's obviously not what we meant. Clearly, people are getting this wrong. We don't know where the misunderstandings are coming from. So you see over and over again that this court has created these monsters. The monsters are coming home. And when it seems really bad for the court, and what I mean by really bad is that it just seems to be unseemly, right? There's a domestic abuser who's involved in multiple shootings and he really wants to keep his guns. The court's embarrassed by this. I mean, except for Thomas, he's never embarrassed. I suppose he's embarrassable. But you have them really sticking to this idea that they're being consistent and they're offering something real and legitimate with this history and tradition idea. But you look at a case like Rahimi and you see that Thomas writes the Bruin opinion, right? And then you get a majority, the conservative majority agrees with it. Rahimi comes up and it's a predictable consequence of Bruin. And really, if you apply Bruin, Rahimi should win. And you've got all of the justices now saying, well, that's not how Bruin needs to be applied. And you've got the author of Bruin saying, of course it is. So the idea that originalism, history, and tradition gives something settled for us, gives us something outside of activism or just judicial chaos monkeys, should be something that we are now abandoning, but I don't know that we are.
Marianne, one tiny gloss on what you just said that I think is so interesting is I hadn't seen the through line until you just pointed it out, that the court's language in Rahimi, which is like, I don't know why all the lower courts are getting this wrong. We were perfectly clear that we didn't mean what Clarence Thomas wrote in Bruin, is exactly the language they used when they adopted the quote unquote ethics code this year, the unenforceable feelings ball ethics code that every jurist gets to decide for him or herself. And it was that same language of like, we've always had this binding code. We don't understand why the people are too dumb to understand that it applies to us. And by the way, it's also kind of the vibe that they directed at the critiques of Steve Vladeck and other people who were pointing out the abuses of the emergency docket, which is like, we don't abuse the you guys must be too stupid to understand how scrupulously we apply our own procedures. So there is this kind of persistent, not just like clean up on aisle 4 vibe, but like, why did you all spill like the pickle juice all over aisle 4 when it's their stinking pickle juice? Okay, Mark, your turn.
I guess I sense that we are feeling the lack of any true swing justice in a lot of different ways that are speculative, admittedly, but feel true to me at least. There's no Justice Kennedy there who could sometimes sort of moderate the conservatives. There's certainly no Justice O'Connor who could sort of build these bridges or give the conservatives reason to tone down their rhetoric or their positions to try not to alienate her. And Chief Justice Roberts looked like he was emerging as a swing vote toward the tail end of the Trump years, in part because there were a few cases like the census citizenship case, the DACA case, where he sided against the Trump administration, largely because of its sloppy lawyering and poorly concealed lies. But now I feel like there really is not any justice who sits in the middle, who can legitimately be won over by the liberal bloc in any meaningful way. And the conservative majority sees no reason to temper its goals and ambitions to try to, limit the alienation that a swing justice might feel. So, I mean, an example here is what's been happening with Barrett. Barrett, as Steve pointed out, has taken a somewhat more moderate stance in some of these cases, right? But she has still never joined with the Chief Justice in a 5-4 decision where the liberals, the Chief and Barrett are in the majority on the merits and the others are in dissent, right? Every time she hedges in this way, it's to sort of pick nits with aspects of the conservative majority's opinion, but ultimately sign on to some or much of it. That was true in the Trump immunity immunity case where she sort of said, well, I don't think it's true that we can't bring in evidence here in this particular discrete circumstance, but I'm signing on to everything else because I might not agree with the framing, but I agree with the bottom line. It was true in the Anderson case where she said, I don't agree with the court's decision to answer this particular question, but I'm still going to sign on to the bulk of the majority's opinion because I don't think Trump can be removed from the ballot. She is still, I think, spiritually very much in the conservative camp. And so the men don't feel the need to do anything to temper their ambitions, I think, to win her over. And so, there's just the three liberals perpetually in dissent, increasingly refusing to pull punches, which I admire. I think Justice Sotomayor's dissent in the Trump case is one of the most terrifying, brutal, blunt pieces of judicial writing I've ever come across. But that is just creating a growing chasm between the two blocks. And I'm not seeing anyone making any effort to build bridges, at least on the right. And that is leading to a court that's totally untempered by any internal dynamics that used to exist, that sort of kept its most extreme temptations in check.
So this is Steve. I mean, I agree with all of that. I would just say that, Mark's frustration with Justice Barrett, I would just direct to her, ironically, right at Chief Justice Roberts, because I think the real sort of individual story of the term is John Roberts is done trying to be an institutionalist. And, if we look back to 2019 and 2020, when Kavanaugh was early on the court, when you still had Ginsburg with the other three Democratic appointees, we saw the Roberts who we had seen for much of the first 10, 15 years of his time on the court, who was, conservative, but not crazy, and who was actually trying to keep the court at least to some degree together, who was writing narrow opinions, who was trying to sort of keep everyone on side in the Trump cases in 2020 especially. And I'm struck this term by how much he just didn't care. And you see this in his opinion in Trump. You see this in his opinion in the Chevron cases, Loper Bright and Relentless. I mean, you see this in his opinions in the Colorado ballot case, in Fisher. I mean, there's opinion after opinion where instead of trying to actually build any consensus, either within the court or outside of it, John Roberts just basically threw his lot in with the Thomas Alito Gorsuch wing. And that's a really big deal, because if Roberts isn't going to be an institutionalist, who is? Who other than Barrett is going to even tepidly stand up for, the court's relationship with the rest of the government and with all of us among that block of justices? It's really striking that John Roberts has sort of gone all the way over to this side, but I think it's undeniable.
And Steve, I would just note two quick things. I completely agree. I think the story of the term is John Roberts becomes a MAGA justice. I mean, he just becomes in line with where Thomas and Alito have been all along. It's almost like he got tired of being that fourth lone, guy who would hive off and vote with the liberals. He wants his court back. And so he's going to take it back by being them. And I think the other subtle point you're making that's worth drawing out really explicitly is that whatever Barrett is doing, I don't see it necessarily as institutionalism. I think it's kind of course correction, error correction. You got too far out. But I don't think she's lying awake at night fussed about the institutional regard for the court. And we imputed that to John Roberts for years, for decades, I would say. And I think that's gone. I don't want to spend a ton of time on lawyerly deconstruction of the immunity case, or, we've all seen the flowcharts of there's still a path to presidential prosecution after the case, in no small part because it just feels like what lawyers are trained to do. And in light of the murkiness of the opinion, it might be unhelpful to spend a lot of time on these decision trees. But it does seem very significant to me that the court took looking at motive off the table. That didn't get, I think, enough airtime in the at least initial cycle of what happened in this case. I think it's actually singularly important if you can't inquire into a president's motive to define the line between official and unofficial acts. It feels like you're a prosecutor in a criminal case. That's like taking away your shoes and socks and saying run the mile. So as best as we can understand it, will one of you walk through stipulated, I guess, a president can someday order an assassination of a rival. President can take a bribe for a pardon. I guess that's okay. A president can tell his or her Justice Department to just go after someone who tweeted an insult. Can you just walk me through what hauling motive out of this analysis does to us?
So, Dahlia, I think the part about motive has to be read in tandem with the part about evidence that I mentioned earlier, which is actually a place where Barrett says she agrees with the dissent. So this is a 5-4 holding here. The majority says that the Constitution limits the introduction of official acts as evidence in a criminal prosecution of a president beyond the limits afforded by executive privilege, which creates this really sprawling safeguard for the president against the introduction of evidence, including motive, that could persuade a jury that he, in his unofficial acts, was attempting to engage in a criminal scheme. I think the way that Roberts wrote the opinion almost ensures that it will hamstring prosecutors in the way you said, because he gives the president this weapon he can use in court to say, I was doing that pursuant to my constitutional duties. I was doing that because that is how I interpret taking care that the law be faithfully executed. That is how I interpret my use of executive power. And now prosecutors cannot introduce evidence of motive that, in fact, he was not doing it because he was trying to take care that the laws be faithfully executed. He was doing it for a corrupt purpose of furthering a criminal conspiracy. And they can't even introduce evidence that in his use of these official acts, he was engaged in a criminal conspiracy whose fruits involved unofficial acts. It's just like if you keep reading the opinion over and over, you see all of the ways that Roberts has boxed in prosecutors. And so when the decision first came out, I saw some commentators saying it's not as bad as it seems. There's still room for prosecutors to salvage the indictment. But if you look at all of the traps that Roberts set, I'm just not convinced that that's actually true on the ground.
The only thing I'd add to that is what is so galling about all of this is the justification for not looking at motive is basically the problem of a bad translation. So in the civil context, the Supreme Court said in Nixon versus Fitzgerald, the big case about absolute immunity for civil damages for outer perimeter conduct, that you can't look into motive. That was because of a very nerdy, lawyer thing, which is otherwise it wouldn't be possible to resolve a president's immunity defense through a motion to dismiss. Right? That if a plaintiff says, oh, the president did this for bad reasons, that would usually get you past a motion to dismiss and to discovery in a civil case. And that's why the Supreme Court in Nixon versus Fitzgerald says we're not going to do that. That makes no sense in a criminal case, right? A criminal case, we're not worried about discovery. We're not worried about summary judgment. We're just worried about, how do you prove if the defendant did the thing he did? And so I understand that John Roberts and Brett Kavanaugh are hyper committed to the powers of the presidency. They have been their whole careers. The problem with the majority opinion is that it starts from the premise that there is all this power, which is itself highly contestable, as both Sotomayor's and Jackson's dissents make clear, and then maps on these really, really bad, mistranslated procedural ideas to basically, as Mark says, box in future prosecutors for no other reason than because they can. That to me is what's so galling about where the court ends up, and why I think even if you are more sympathetic to the idea that the president should have some immunity, the right opinion is clearly Barrett's, not the Chief's. And just why it's so maddening to me that the Chief couldn't somehow find a way to bring himself to join that.
We are pausing now for some messages from our sponsors. This episode is brought to you by NetSuite. Quick math. The less your business spends on operations, on multiple systems, on delivering your product or service, the more margin you have and the more money you keep. But with higher expenses on materials, employees, distribution, and borrowing, everything costs more. So, to reduce costs and headaches, smart businesses are graduating to NetSuite by Oracle. NetSuite is the #1 cloud financial system, bringing accounting, financial management, inventory, HR into one platform and one source of truth. With NetSuite, you reduce IT costs because NetSuite lives in the cloud with no hardware required, accessed from anywhere. You cut the cost of maintaining multiple systems because you've got one unified business management suite. You improve efficiency by bringing all your major business processes into one platform, slashing manual tasks and errors. Over 37,000 companies have already made the move, so do the math. See how you'll profit with NetSuite. By popular demand, NetSuite has extended its one-of-a-kind flexible financing program for a few more weeks. Head to netsuite.com/amicus, netsuite.com/amicus, netsuite.com/amicus. I do want to tell you about my cat. Her name is Arby. My boys named her after RBG, and she has a little white descent collar. Anyway, this is not even about Arby. This is about how Litter Robot actually makes it possible to never have to scoop cat litter again, which means you never, ever have to think about scooping litter again, which means you can take that chunk of your brain that is always thinking about the litter box and deploy it elsewhere. Litter Robot's self-cleaning technology automatically cleans after every single use, so your cat will always have fresh litter. Litter Robot sends a notification to your phone when it needs to be emptied. As a special offer to listeners of this show, go to stopscooping.com/amicus and enter promo code amicus to save an extra $50 on any Litter Robot bundle. That's an extra $50 off any Litter Robot bundle at stopscooping.com/amicus and enter promo code amicus at checkout. Stopscooping.com/amicus and enter promo code amicus. Let's return to my conversation with Marianne Franks, Steve Vladeck, and Mark Joseph Stern. Marianne, one of the big stories, Steve mentioned it, it was the theme of last term, but now it's like supercharged, is the court's self-aggrandizement this term. And this month, we've literally seen the justices weighing in on granular details about air pollution and how guns work and, emergency room stabilization protocols for miscarrying women and homelessness. Like, there's nothing they're not experts on. If there were ever any doubt about it, the Supreme Court is the policymaker for all policies in the country, and the conservatives are really comfortable just announcing that they're experts on clean water and air pollution. Are we supposed to believe here that there's something scientific and methodologically sound that is happening when the justices do this? Or is this just, we all, sort of legal realists now, this is just politics by another name? I mean, how do you, as somebody who thinks about the court, think about justices who have not just sort of structurally arrogated all this power, but feel, as Steve says, like no shame, perfectly comfortable in wading in and telling us how we're going to regulate drugs now?
It is an amazing move on the one hand that you have this degradation, this contempt for actual expertise, right, in any number of fields, whether that's history or whether that's science or whether that's medicine. And at the same time, as you're saying, the court is also putting itself in the position to say, well, none of these experts know anything, but the court gets to decide everything. And it's been more embarrassing this term than most because, of course, this has been the term where the justices have made mistakes about what chemicals they're talking about and about, how to even refer to certain types of procedures. They expose the fact that they don't know what they're talking about. And here I should clarify the conservative justices, because the liberal justices have been pretty good about saying we actually do think expertise matters. So yes, you can never get a consistency from the far right of the court, except in the sense that I always go back and think about the phrasing in 2016 when the election results were looking uncertain and Trump was asked, are you going to respect the outcome of this election? He says, I will respect it if I win. And I think that just has defined this entire moment we're living in. It's where the conservatives say, I will respect whatever it is, science, expertise, law, whatever it is, if we win, and that's it. And it's really depressing for me as a law professor to have to confront that, because it seems, as a professor, we like things to be interesting and complicated and not just naked power grabs. And it's a story about a bad, the bad guy doing bad things. And it's such a boring and really depressing villain narrative, but it's really that clear. It's any rule that they want to set up is purely for the sake of, can the far right in America use this to their advantage? And that is the rule that they will endorse. And as soon as it might be used by the other side, they will find a way to say that we didn't mean you guys. And I just think that that's one of the most incredibly depressing things about this cycle, even though we've seen it happen for some time. And of course, it was never the case that the judicial branch was free of this sort of bad motivation, but it's so clear now to say, well, we are holding the courts hostage, and therefore we can just take all the power for ourselves. We can take the executive, we can take the legislative, we own everything, and we will make sure that we are the final arbiters of what gets cast as not just, law, but truth itself all the time, over and over again. And there's no shame about that. There's no shame of these justices saying, we can do this better than experts. We can do this better than scholars. We can do this better than scientists because we are somehow, divine, I guess, is what they're actually trying to communicate to us.
I love what you're saying because it's a really crisp answer to the question everybody was asking on Monday, which is how is the same court that has fundamentally dismantled the administrative state creating an imperial presidency? And your answer is no, in both of those moves, they created an imperial juristocracy, right? Like they gave themselves the power to both dismantle the parts of the executive branch and also immunize others. And that's, in the end of the day, there's one player here. Mark, I feel like you had a thought, or am I misreading your face there?
I mean, I just keep going back to Neil Gorsuch and his opinion blocking the EPA's plan to limit ozone pollution, repeatedly mistaking nitrogen oxide, which is the pollutant that causes smog, with nitrous oxide, which is laughing gas, resulting in an opinion that repeatedly purports to limit the EPA's ability to regulate laughing gas in upwind states. If you needed a clearer illustration of why the Supreme Court should not be seizing these deeply in the weeds policy decisions for itself, like, you couldn't look at a better one than that. I also think it's really interesting that Barrett dissented in that case, but joined so many of these other decisions that are awarding the judiciary more power and stripping it away from the executive branch and from Congress. And I just think that goes to how she's so fundamentally conservative, but she has a limit for BS. This is the frame I always look at her through, as like Professor Barrett. Like sometimes when she's dissenting, it's like she's grading a bad student's paper and like taking her red pen and explaining all of the mistakes. That was her EPA dissent, I feel like, looking at Gorsuch and being like, oh, wow, you are a C- student at best. But when it comes to the broad stuff, giving the court all this power to keep issuing C- decisions, blocking agency rules, she's on board. So it's like she's still got one foot firmly planted in this camp of total judicial supremacy over the other branches, and the Supreme Court should be deciding every agency action for now and forever. But then when the court starts to get into the weeds, sometimes she's showing signs of rationality. I wonder if that is room for evolution for her, if there's a little bit of cognitive dissonance she's perhaps experiencing when the rubber hits the road and the court actually has to decide these issues and does so poorly, or if she's still just very much learning on the job. And at the end of the day, Professor Barrett still can't see a C- paper and let it pass without comment.
Steve, I want to turn to you and ask a question. Mark and I spent the better part of this spring kind of like mud wrestling, we think, originalism to the ground in a decisive victory for cherry-picked history is not, in fact, a methodology. The day after Anderson, the Colorado ballot case came down, I remember you texting me to say, like, bye-bye, originalism. Now we just do purposivism. I would love you to explain to me if there is, in fact, some unified originalist theory that has prevailed at the court. I gotta say, I don't read the immunity case as a really, like, rock-solid effort at originalism, but is there some surviving coherent theory of originalism that we can apply to whatever it is that happened this term?
No. Sorry.
Excellent.
You want more
Next
word?
question.
No, was there more?
I mean, no. See footnote. I really think that originalism is going to continue after this term. There's a new kind of originalism that Justice Barrett debuted in one of her opinions, original contours originalism. It's a whole new flavor. It's a pumpkin spice type of originalism.
Surprise.
It's also shapewear. Okay, keep going.
Is it seasonal, or do we do that in the fall and then we've got a whole new one by the spring?
I think we take the summer off at least. So back to Barrett, who I am going to, I think, continue defending against Mark for the duration of the podcast today. I think there's something quite striking in her separate concurrence in the trademark case, Vidal versus Elster. I think it was also in the CFPB case where she joined Justice Kagan's concurrence, where she is actually staking out a position on originalism that is very different from the one that's being embraced by Justice Thomas and usually Gorsuch and Alito, that I think is more malleable is not the word I want to say, but sort of closer to Justice Kagan on the idea that like originalism matters, but is not either objective or exclusive. And that's relevant to me in two respects. One, I think it's further to her credit that she's showing some independence. Two, it undermines the whole damn project. Whoever's flavor of originalism you find more persuasive, there's just no good argument that any justice on the Supreme Court is consistently applying anything that you could reasonably call a single coherent approach to originalism. Maybe there are law professors out there who can write articles in which they try to claim that they have a unifying theory that covers all of the bases. Good luck when they get to executive power. But the reality is that like anyone who's still trying to argue with a straight face that the Supreme Court, at least, is applying one objective, coherent, easily described approach to how we should interpret the Constitution based on founding era materials, is lying at this point.
Marianne, you think so much about the use of history in the context of, vulnerable communities and powerful communities. And one of the reasons I so wanted to hear your voice this week is because so many of the themes of the term feel like they're in your wheelhouse, which is to say women and violence and guns and power and the use of history to sort of reify those structural relationships. And I know the hot take, and it's, I think, just a wrong-headed hot take, is that it's okay because the court punted on both abortion cases, and they punted, as you said at the start, on Rahimi, which is really the most toxic of the two gun cases. So maybe it's just a push. Maybe women and power and violence didn't sort of become the theme of the term. But I know you're not sanguine about any of that. You wrote in a piece for Ms. Magazine, quote, "The threat posed by violent abusers like Zaki Rahimi might be temporarily disarmed today, but the threat posed by the Supreme Court's patriarchal agenda remains a loaded weapon," end quote. And I would just really like to hear from you because I know there's a lot of folks out there who are like, okay, I'm dialed up on, attacks on democracy, but the court seems to have chilled on, women and violence and vulnerable communities. And I would love to hear your take on how that would be wrongheaded in the extreme.
Yes. And this has been pointed out. I know that you and Mark had pointed this out about, these things that maybe seem like wins, but only if the bar is in hell. And also they're really just not wins. They're just pushing issues down the road, right? So we see this with the reproductive rights cases. The fact that you even had a case like the Mifepriston case is just ridiculous. And the fact that the worst thing didn't happen in that case is not really a cause for celebration. And that's also, of course, true when we're talking about the EMTALA case, the Moyle case. Justice Jackson, I think, gets it exactly right when she says that, and we did take this case, right? We have interfered. We are part of this conversation now. And to just sort of disclaim it and say, well, we shouldn't have granted cert there and backing away, I think she's really calling out the court for more than just that decision. That's kind of a move she sees the court doing generally, where you set things in motion or you directly intervene or you have caused these things to happen, and then the court backs away and says, well, so the lower courts or people can't sort this out, or the government gets it wrong, or everybody's misunderstanding our clear instructions. But what we're left with is, I think, what you alluded to before, which is that if we're looking at the most vulnerable communities in the context of these decisions, you get this extraordinary thing that I've referred to in the past as victim claiming, right? This reversal where the most powerful members of society are treated as if they are victims, as if they are vulnerable and they need extra protections. And you take the most vulnerable members of society and you present them as having all this power that needs to be checked, right? So what the court is doing, in effect, regardless of the details of any of its decisions, it's saying it is okay to criminalize doctors who provide life-saving care. It is okay to criminalize women who are trying to save their own lives. It is okay to criminalize people who are experiencing homelessness. But what it's not okay to do is it's not okay to have any checks on the most powerful person in the United States. And if you want to be an insurrectionist, right, maybe we're going to also cut you some slack. So it's so clear that what is being said here is that we really are gung-ho on criminalization and punishment of those who have always been exploited and have always been kind of marginalized. And the people who are at the top are constantly being recast as somehow in need of special protections. And you get things like the presidential immunity case. But it's such a vicious inversion. And it's so distracting in a way because, as has been talked about already, there's a kind of legitimization project also going on at the same time with the court where that backing away thing is trying to say, but look, we're not that cruel. If you thought that we were just going to take away these medications and we were going to never let women have emergency room abortions, see, we're not doing that. We're not monsters. And the same thing in the Rahimi case, right? It's like, oh yeah, we're going to let that guy not have his guns for a while. But all of this, it's just going to keep coming back. It's designed for it to come back, right? That this is going to get litigated and litigated and litigated. And what is happening is that the assumptions and the goalposts are moving further and further in this horrible, cruel direction where things are just starting to be taken for granted that you're allowed to just gamble with women's lives. You're just allowed to use the power of the state to crush people who are at the margins of society, whereas all the people who get to make those decisions are somehow presented, again, as if they need extra help, right? Because it really is this question of incentives, right? Who's getting the message, right? The president's getting, whoever, the future president here, because we've already seen that, a Democratic president says, well, I'm not going to take any of these horrible powers that I've just been given. But we all know that a Republican president is not going to be so scrupulous. So we know that the message being sent is do whatever you want and you will be protected. Whereas for everyone else, it is, screw up once or cross the line of where we think you should stand, right? If you are a woman, if you are actually trying to defend yourself, you're going to get snapped, by the jaws of the state. And the only little bit of, and I don't know if I'm really just grasping at straws here, but to go to the Justice Barrett question about what is happening here in terms of her critiques, some of which I think are really interesting. Her critiques of this new version of, not the new pumpkin spice version, but the history and tradition version, right, that we're getting still, that Kavanaugh and others keep trying to give us, right, and Rahimi was the most embarrassing of these attempts to try to retain the history and tradition approach. Barrett in Vidal really does say some very interesting and blunt things, where she says, I'm just looking this up here, she says the court never explains why hunting for historical forebears on a restriction-by-restriction basis is the right way to analyze the constitutional question. And even better, she says later, relying exclusively on history and tradition may seem like a way of avoiding judge-made tests, but a rule rendering tradition dispositive is itself a judge-made test. Now, that's a very obvious thing that everybody should be saying, and some people have been saying, but it's kind of extraordinary that she is saying and pushing back on this. And I do hope that that's going to be a point where she's going to do more and more to point to the court, in addition to the liberal justices, to say that history and tradition approach is ridiculous. Now, the problem is, of course, I think going to be that even with the liberal justices, they are adopting history and tradition sometimes when it suits their purposes too. And this is a bit of my own hobby horse, but the Counterman decision from last year, this notion that the First Amendment somehow, it's okay to say historical exceptions, long known to the bar, and rely solely on that frozen view of history when it comes to the First Amendment, that's a mistake. And it's a mistake that the liberals keep making. And interestingly enough, Barrett did not.
Just one more data point, I think, to your obviously correct claim about who gets this court's empathy and attention is that on Tuesday's cleanup orders list, the conservative supermajority continued to let the lower courts gut precedent that had protected juvenile defendants against mandatory life without parole and allowed someone who was sentenced to mandatory LWOP at age 16 continue to languish behind bars for his entire life because, he doesn't get the same attention that, say, a corrupt mayor who accepts a $13,000 check as a gratuity receives. And I guess I would just ask if you could weigh in on a debate, Marianne, that I've been having in my head for now, it feels like ages, which is when the conservative majority does this, do they know they're doing it and are they trolling us? Or are they really that oblivious to how their empathy is selectively deployed? Because when the court, on the one hand, allows for the criminalization of homelessness, but then on the other hand, absolves many January 6th defendants of an obstruction charge. When the court is allowing mandatory juvenile life without parole, but showing this extreme solicitude toward corrupt local officials, part of me is like, okay, I'm getting trolled here. Like when these guys write about the dangers of overly broad criminal law and criminalization, Neil Gorsuch is about to write a book on the overcriminalization of America. And yet they are very clearly, I think, engaging in a distortion based on policy preferences of who gets this benefit and who doesn't. I mean, like, are they trolling us, Marianne? Please tell me. Please settle this debate.
I don't know if I can settle the debate, but I can say, is it trolling or is it sincere? And I wonder if the answer is it could be both, right? I'll say a few weeks ago that I was asked to be the Democratic witness in this hearing before the Small Business Committee, of all things, on the conspiracy industrial complex, I believe is what it's called. And the entire move here, and we've seen this with previous committee hearings about the supposed censorship of social media platforms. This is a little bit about what Murthy was about, but also now Republicans are also trying to they have been taking aim at civil society. They've been taking aim at individual researchers. They've been trying to shut down the grants and the organizations that are dedicated to fighting misinformation and disinformation. But the entire hearing, right, is a bunch of Republicans saying the government keeps trying to silence conservatives. And the first thing I was trying to say was, well, you do realize you're the government and you're the ones who are actually you are holding hearings and issuing subpoenas and filing lawsuits against individuals who are speaking out, who are saying misinformation exists, here's some correct information. But they seem absolutely convinced when they say the government is doing these terrible things, it's like they don't think that they are the government, right? That they're so convinced that they're victims that that's all they can see. And that seems to be what's holding the conservatives generally together. And I think the justices are doing the same thing. But to link this a bit to the EMTALA oral arguments, because this is the moment where Justice Alito is talking about the unborn child, when of course the case is supposed to be about emergency care for the woman, right? The woman who's experiencing pregnancy complications. And literally all he can see is the unborn child. So much so that the Solicitor General had to say, it's about, her needs. And he starts to shout. He says, well, no one, right, is suggesting that the woman is not a person, right? But of course, that's exactly what he was suggesting, because he couldn't even see the woman, right? That she was nothing but like a sort of a transparent vessel through which you could see the struggling unborn child that was the thing floating and out of context that needed to be saved. None of which makes any medical, scientific, or moral sense. But it was that, I think, sincere. It was both sincere and also really upsetting for him to have that kind of... So I think it's both. I do think it's trolling, but they also believe it.
Let's take a short break. From Picasso to Cleopatra, the podcast Legacy looks at the lives of some of the most famous people ever to have lived and asks the question, do they have the reputation they deserve? This season, they take a look at J. Edgar Hoover. Hoover was director of the FBI for half a century. An immensely powerful political figure, he was said to know everything about everyone. And he had the ear of 8 presidents, and they were all terrified of him. When asked why he didn't fire Hoover, JFK famously replied, quote, "You don't fire God." From chasing gangsters to pursuing communists to relentlessly persecuting Dr. Martin Luther King and other civil rights activists, Hoover's dirty tricks and tactics have been endlessly echoed in the years since his death. And his political playbook still shapes American politics today. Follow Legacy now wherever you listen to podcasts. You can discover more to the story with Wondery's other top history podcasts, including American Scandal, Black History for Real, and even The Royals.
This is the story of the one. As head of maintenance at a concert hall, he knows the show must always go on. That's why he works behind the scenes, ensuring every light is working, the HVAC is humming, and his facility shines. With Grainger's supplies and solutions for every challenge he faces, plus 24/7 customer support, his venue never misses a beat. Call quickgrainger.com or just stop by. Grainger, for the ones who get it done.
More now with Steve, Vladeck, Marianne Franks, Mark Stern, and me, looking back on a Supreme Court term that has left us reeling.
So, Marianne, this is Steve. I'm so glad you brought up the EMTALA case because it's not just the oral argument that I was thinking of as you and Mark were having this exchange, but Alito's dissent. When the court dumped out of the case, which, by the way, is itself a story unto itself. I mean, this was a case they never should have taken in the first place. Like, they jumped over the Ninth Circuit, and then they're like, oh, whoops. But Alito's dissent in the EMTALA case, I think, perfectly captures exactly what you and Mark were just talking about, and is, to me, one of the scariest opinions of the term. Because the pregnant person, the actual person who Congress passed EMTALA to worry about, the patient who presents with an emergency medical condition, is just never mind in the whole freaking opinion, as, he would effectively take a blowtorch to this really important federal statute that's actually really important in lots of contexts having nothing to do with reproductive care, right? And it's really important for ensuring just meaningful access to emergency medical care for poor people. And I'm so struck by that because it just seems like, it's one thing that we hear that from the Alito, Thomas, Gorsuch faction. I think we're getting a little bit inured to that at this point. It's another thing that the other three Republican appointees almost never call them out on it. And even when Justice Barrett was fairly critical of other parts of Alito's dissent in her concurrence in the EMTALA case, she has nothing to say about the way that the case is completely misframed, and instead goes on this tangent about how there are actually hard questions about whether Congress in a spending clause statute can make a spending condition a violation of state law. No, there aren't. Right? If Congress can pass a statute, the statute can authorize or even require conduct in violation of state law. That is Supremacy Clause 101. So it is the othering that is just intrinsic in especially the separate opinions we're getting in these cases is such an ominous sign of where we're going. It also comes through in Barrett's majority opinion in the Munoz case about the rights of a U.S. citizen to the immigration status of a non-citizen spouse. Mark's talked before about the implications this has for same-sex couples especially. And I wonder if the implications were less in that space and more in a space that was more familiar to the conservative justices, if they might have been more aware of them and more worried about them.
I wonder, Steve, if one of the things you're poking at here, which I think is really sort of loud and clear in terms of the tone of majority opinions and dissents, is not just the othering of others, which you guys have been talking about, but the othering of one another in that EMTALA fight between Justice Alito and his sense of why Justice Barrett and the other quote-unquote moderates had tiptoed away from kind of closing the deal on EMTALA in favor of Idaho. And just the language of like, this is too emotional, this is too triggering. And then again, that same tone in the majority opinion in the Trump immunity case, where it's just this kind of like weird gaslighting / you're hysterical, they're little ladies, you're overreading the opinion with all this parade of horribles. And then at the same time, not addressing them, like kind of criticizing the Sotomayor dissent and the Jackson dissent for being overwrought, and yet not addressing the actual, sort of criticizing the tone and not the substance. And it all feels like some version of what you're saying, Steve, which is not just rendering sort of the marginalized people invisible the way Marianne and Mark have suggested, but literally rendering the other half of the court invisible or trivial or unserious in a way that I think illegitimate, in a way that I just think is quite new and really, really damaging. I want to, before we say goodbye, I think I want to ask the sort of big brain question that I've been sitting with, which is, we've barely talked about the ethics scandals. We've barely talked about the fact that, 3 of the justices who decided the immunity case were appointed by Donald Trump himself. 2 certainly have signaled a certain enthusiasm for some of the January 6th activities. We haven't talked about this legitimacy crisis, but I think that, Steve, you made the point up top that there appear to be 6 justices who don't care that there's a legitimacy crisis at all. And that the other theme that I just want to pull at for a minute is we framed the Trump case incorrectly insofar as I think it is, in fact, a democracy case. In this one sense, writing for the ages, the majority has the right of it. This is fundamentally reshaping how we do separation of powers and how we think about the rule of law going forward. But the other theme that came back over and over and over again this term is the theme of just contempt all the way down for democracy, Justice Department, bunch of political hacks who could indict a ham sandwich, agency experts who are just like beady-eyed bureaucrats who don't care about freedom, the rights of billionaires, as long as they do it in the form of after-the-fact gratuity, criminalizing the poor and the homeless, as Marianne said. I worry, and I think this is where I started, that this term is so much more than Donald Trump and immunity. It dovetails with Project 2025. It dovetails with this effort to dismantle government and trust in government. There's a layer of this, which is, and by the way, do your own arming up, get your bump stock out because nobody is to be trusted. And I said, I think on Twitter, it's just time to hand this whole conversation over to the authoritarianism watchers now, because this is not law anymore. But I wonder if you could talk, each of you, for a minute, and maybe we'll start with you, Steve, about what the sort of aggregate effect of the court signaling over and over and over again that it doesn't have much respect for democracy or rule of law or separation of powers or government itself, because I'm taking that into the 2024 election, and that's bigger even than the Trump story.
It's so much bigger. And so I actually think the defining moment of the term, and you guys are going to laugh because this is such a me thing to say, was the court's unsigned, unexplained 5-4 order in January in the razor wire case. So just to remind folks, right, this was a dispute about whether the Biden administration could remove the razor wire that Governor Abbott had placed along the U.S.-Mexico border in Texas. And, should have been an open and shut, straightforward case. The Fifth Circuit did a Fifth Circuit and made it messy. And what's striking is not that it was it's striking it was 5-4 with Barrett and Roberts. Hey, Mark, there's one non-merits example, right, joining the 3 Democrats in the majority. What was striking to me was the reaction. So by that afternoon, if not the next day, you had Chip Roy, congressman from Texas, Ted Cruz's former chief of staff, on Fox News urging Governor Abbott to defy that ruling. And that didn't get a lot of play nationally. It didn't get a lot of attention. But that should have been a 5-alarm fire for the justices, that a prominent, well-liked, at least in certain circles, right-wing member of Congress with a lot of sway is going on national television telling the governor of Texas to ignore this Supreme Court. That's the future. And it's especially the future in a second Trump administration in those cases in which the court finds its backbone. And if I were a Supreme Court justice, I would be terrified that that became more than just an isolated event. So, Dahlia, to your point about sort of the court's view of itself and its relationship with all of the other institutions in government, that should have been an inflection point. And everything that happened in the 5 months since has suggested to me that no one on the court seems to have gotten it, and certainly none of the 6 Republican appointees. And I'll just say, I really hope we never find out how much of a mistake that was and how short-sighted it was on their part to not care more about their credibility, even among those who don't usually agree with the court. Because if you start having, President Trump supporters in the second Trump administration saying, why do we follow this court that so many other people have already criticized? I'm not sure who's going to be left to stand up for the court at that point.
I'm not sure if my heart can take 2 more answers to this question, but
let me just try to infuse some fighting spirit into mine, and then we'll kick it to Marianne, and she's going to make us all feel better, right? I think that what we've seen, especially over the last few weeks, shows how unfortunate it is that Democrats have chosen, by and large, not to run against the Supreme Court in 2024. Not just the president, but senatorial candidates seem to have decided that it's just too confusing and attenuated to run against the court, and that they should run against Trump and MAGA instead. Well, I increasingly think that MAGA and the Supreme Court are one and the same, and that the Supreme Court is very much committed, as you noted earlier, Dahlia, to implementing the Trump agenda, a kind of Project 2025, whether or not Trump wins. And that if somehow Democrats pull off even, say, a huge victory in 2024, that they will be confronted with a Supreme Court that's going to be living in an alternate world in which Donald Trump won and all of his powers were just sucked into the judiciary. There will be Trump appointees like Matt Kaczmarek all over the lower courts blocking every single agency action before it can even be published, right? There will be Fifth Circuit decisions that make the crazy ones from this term look reasonable. And the Supreme Court itself will have 5 or 6 votes to frequently embrace these rather extraordinary, hardcore conservative decisions. And so I'll say, like, for me, what I want progressives to do is look at the Supreme Court and recognize that it is restructuring government without any kind of mandate from the people, without any of those justices obviously ever getting elected or winning a single vote, and realize that that is the most existential threat to democracy. That a single decision like the Trump immunity case is horrible and is terrifying, but it has to be seen as part of this broader pattern of the United States Supreme Court restructuring representative democracy to make it less representative and less democratic. And that is where the fight needs to be. It isn't there now, but there's still time left.
Marianne, I think I'm going to give you the last word with the caveat, 2 caveats. People are exhausted and they're sad. I am exhausted and sad, but I don't think anybody has helped me understand better than you what happens in a world where the rule of law is dismantled and oligarchs and men with guns roam free and there is no law protecting the rest of us. And it does feel to me as though we tilted further into that world this term. But you don't have to give us hope. That Mark did a very good job reminding us that it's not ultimately up to the court whether this happens or not. But I would love to just have your thoughts on this question of what do you do when the court has become an echo of the voice that wants to shrink government down to the size that you could drown it in a bathtub? I mean, that's full on the language of this court now, or the majority.
I'm not sure. And when I think about what could change the tide here, when I think about just how much it has become obvious how cruel the consequences of these decisions, how vivid these consequences are, and it doesn't seem to matter, right? The people who are responsible for them and the people who are supporting them are confident. They are absolutely confident that the cruelty will never come for them. So I guess one way of thinking about trying to change the path is, what if people understood that the cruelty will come for them? Is there a moment where there is a popular understanding that when you have an unprincipled, thoroughly untethered from any kind of rule of law, any kind of moral code, any kind of consistency, when you have that in place of a functioning democracy, that no one is safe? Can people understand that they too will not be safe at some point? The problem, I think, right now is that when you have this power grab, this is the best version of the far right saying, we will make sure that they never have to worry about that they will always be kept safe. But, I think no one should trust any form of government, right? That includes the courts, that includes the federal government, that includes the state governors, right? Trying to locate some of that sense of suspicion, that power concentrated in this way, just purely on the whims of the powerful, isn't going to serve the people's interests, and for people to understand that. The other thing that I think might happen, because so much of this is tied up with a certain kind of patriarchal resurgence, is to understand that this is a position of weakness. This kind of theocratic, thoroughly partisan cruelty is weakness. So when you mentioned before about how there's this disparagement of the female justices as being emotional and hysterical and just responding to sort of feelings, that is, in fact, of course, every accusation is a confession, right? That is exactly what is characterizing the far right now. They know they can't win unless they cheat. They know they can't win if the rules apply to both sides. So we're back to this statement, right? We're back to the Trumpian sentiment that I only respect the rules when I win. That's also another way of saying I can't win if the rules are in place. I would like to believe that there is some subset of conservatives out there that are actually quite angry about that idea, that they can't compete, that if there's a fair chance, that they would lose over and over and over again, and that they'll get angry enough about that it'll push them towards the concept of reciprocity that you and I talked about before with my previous book, In the Cult of the Constitution, because that's the only democratic principle. The idea that we have to have the same principles for everyone, the same rule applies to everyone, and the fact that you're losing doesn't mean that means the game is rigged. You might have just lost, and you should have lost. So will there be some attempt on the part of some conservatives to say, we don't want to be losers all the time. We don't want to have to admit that we're losers and have to change the rules every time. We actually think we can compete if the rules are fair and the principles are real. I think that's actually our only chance.
Dr. Marianne Franks is the Eugene L. and Barbara A. Bernard Professor in Intellectual Property, Technology, and Civil Rights Law at the George Washington University Law School. Her book, Fearless Speech, comes out this October. Marianne, can you tell us about it?
I'd be happy to. So the subtitle of Fearless Speech is Breaking Free from the First Amendment. And I'm attempting in this book to say, we've been too limited, especially Americans have been too limited by the legalistic concept of the First Amendment and the doctrinal complexities. And we've actually really been missing out on an opportunity to conceive of freedom of speech in the way that the Greeks, I think, did very long ago when they said, Parrhesia is fearless speech. It's speaking truth to power. It's making yourself vulnerable. It's about taking some kind of risk in your critique, but taking it upon yourself as opposed to a reckless kind of speech that pushes risk onto other people. So I'm really trying to make the point that the First Amendment has constrained us in this way. We can think around and outside of it, and we should really be uplifting and confronting and embracing truly fearless speech over reckless speech and admire those examples. And I try to do them justice in my book.
Cannot wait, Marianne. We'll have you back on when the book comes out. Stephen Vladeck is a professor of law at the Georgetown University Law Center, newly transplanted, nationally recognized expert on the federal courts, constitutional law, national security law, and military justice. And his book, The Shadow Docket, I think shaped so much of how we think about the Supreme Court on this show. Thank you, Steve.
Thanks for having me, Dahlia.
Mark Joseph Stern, my ride or die. We are creeping to the end of this, Mark, and you have been a hero in every single way. Thank you for joining us.
Thank you, Dahlia.
And that is a wrap for this Breakfast Table episode of Amicus. Thank you so much for listening in. Slate Plus listeners, thank you so much for your support these past few weeks through what felt like the forever of Opinionpalooza. We could not have done it without you. If you are not a Slate Plus member but would like to show your support for the work we do here on the show and at the magazine, and if you'd like to access all of Slate podcasts ad-free, never hit a paywall on slate.com, and you would like an invite to the cigar bar at the bottom of my garden that is Amicus Plus, you can always become a Slate Plus member by going to slate.com/Amicus Plus or by clicking Try Free at the top of our show page if you're listening in Apple Podcasts. Thank you so much for your letters and your questions. You can keep in touch at amicus@slate.com, or you can find us at facebook.com/Amicus Podcast. Sarah Birmingham is Amicus's senior producer. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor. And Ben Richmond is our senior director of operations. A big old shout out to Sol Worthen for helping us through the maelstrom of Opinionpalooza. And we'll be back with another episode of Amicus next week. Until then, hang on in there.